right, our third case this morning is 2019-1058 in the matter of the complaint of Direct Energy Business LLC versus Duke Energy, Ohio. For the appellant, Ms. Brahma.
Thank you, Madam Chief Justice and Justices of the Court. My name is Elizabeth Brahma with Taft, Stettinius, and Hollister. I'm appearing today on behalf of Duke Energy, and I would like to reserve 3 minutes for rebuttal if I could. This case arises today because the Public Utilities Commission of Ohio made determinations about Duke Energy Ohio activities and potential remedies related to those activities that are within the exclusive jurisdiction of the Federal Energy Regulatory Commission, or FERC, as explicitly recognized by the tariff for the state, which was approved by the State Commission. The background that's pertinent to this matter is laid out in detail in the parties' briefs, so I will not revisit it here. It's important to be clear, however, what activities are and are not at issue. In the arrangement at issue before this court, Direct Energy obtains power from PJM, the Regional Transmission Organization, or RTO. Duke provides services to Direct Energy to facilitate Direct Energy's purchases from PJM, and PJM in turn bills Direct Energy for services under the Federal Open Access Transmission Tariff. Duke's activities were to supply hourly load data in accordance with the Open Access Transmission Tariff, otherwise known as the OAT. This is explicitly recognized in the state tariff. In other words, all of Duke's activities, really the singular activity at issue here, which is to supply hourly load data, is premised on a federal tariff, which prescribes both the method in which hourly load data should be supplied, as well as the remedies in the event that there are any questions or issues about the manner in which that data is supplied. Duke's merit brief outlines 4 legal errors in the Commission's April 2019 opinion and order and the June 2019 entry on rehearing. Given the time for oral argument, I intend to focus my argument on 3 key areas: the Commission's lack of subject matter jurisdiction in this area, the conflict between the Commission's conclusions and state law, and where the state tariff and laws require certain findings the Commission neither made nor had jurisdiction to make in any respect. So I'd like to start with the issue that the Commission lacked subject matter jurisdiction to make any determinations about whether or not the Duke Energy's issued or provided adequate service, given that the federal tariff governs this matter. The Public Utilities Commission of Ohio had no jurisdiction.
Before you start that, let me ask you, analytically, do we look at whether there is preemption first, or do we look at whether or not PUCO had subject matter jurisdiction based on the definition of a public utility? Do we have to do those? Do we have to make those inquiries in one order or another?
The issue, the primary issue that I would argue is one of the fact that the Commission lacked jurisdiction because of federal preemption. That is the first issue. And if the court finds that the determination of whether the utility or whether, Duke Energy provided hourly load data in accordance with the federal tariff is in fact a matter of federal determination, there's no need to make any further determinations about whether the Commission had subject matter jurisdiction otherwise, because the sole issue before us today is whether the Duke provided and supplied hourly load data in accordance with the federal tariff. As
Counsel, aren't we, first concerned on whether Duke, in its capacity in relationship with Direct, occupies the status of a public utility under Ohio law?
That is also an issue before this court. But even if you were to find that Duke was a public utility in some respects, where we have a federal tariff that governs the activities of the utility or of Direct Energy, of Duke, that federal tariff is what ultimately governs how the services are to be provided and whether a remedy is available.
Well, right, because that's when you get to the preemption issue. But let's go back and take a look at the statute and whether or not Duke enjoys the status of an energy, or excuse me, a public utility, which would come under the auspices of PUCO. And if they don't, all right, that's the end of the discussion, I would imagine.
Correct. I agree with that as well, Your Honor. And the issue, I think, there is when they're not necessarily directly related, although they are both determinations this court can make. The state statute definition of public utility turns on whether or not Duke is acting as an electric light company or an electric utility in its capacity supplying hourly load data. The definition of the state statute with respect to whether or not Duke was acting as an electric light company speaks to supplying electricity or supplying transmission services. Those are not the activities that Duke was involved in with respect to this matter.
So then that means that they're not a public utility subject to PUCO's jurisdiction.
I would agree with that. And I would also say that with respect to the specific issues that are raised, that Duke has raised in its brief with respect to whether or not the state law precludes exculpatory clauses in tariffs, and also whether the commission has to determine whether Duke provided adequate service. Those only apply to public utilities. And where Duke was not acting as a public utility, there is no bar against an exculpatory clause, nor is there any basis for the commission to find that there was inadequate service in this instance. The reason I wanted to start the issue or my discussion with the federal tariff is because it is straightforward on the face of the commission's orders and on the face of the state tariff. The opinion and order of the commission, as well as the entry on rehearing, both acknowledge that Duke's obligation was to supply hourly load data in accordance with the open access transmission tariff. This federal tariff, notably the state tariff doesn't say that there is some additional state requirement. It is literally a direct referral to the open access transmission tariff. And it is in its entry on rehearing that the commission specifically found that because there was an issue with respect to whether it supplied hourly load data in accordance with the federal tariff, that was inadequate service. That is the state commission treading directly in an area that is governed by a federal tariff and is preempted by FERC's jurisdiction in this area.
What kind of, are you saying this is conflict preemption, or what kind of preemption are you arguing?
This isn't a preemption in the sense that not so much that there is a conflict, because it does say in accordance with the open access transmission tariff, but the case law cited by Duke in its merit brief, and gives several examples. The California XRL Lockyer case, the AEP case, indicate that where FERC has jurisdiction over a matter, and not just the rate itself, but the process and the remedy, that is FERC's exclusive jurisdiction. And the state is not to either infringe on that area or graft additional remedies.
Well, since some of those cases have been decided, the U.S. Supreme Court has issued the Virginia uranium case, which seems to kind of move the ball a little bit on preemption. And I think what the court says is there must be, you must point to a statute that displaces or conflicts with state law. So what is the conflict here, or what is the direct displacement?
The direct displacement is set forth in the state tariff itself and in the federal tariff, which acts like a law according to a number of provisions of both United States District or Circuit Courts, as well as United States Supreme Court. In this case, we have a state tariff that explicitly acknowledges that whether or not Duke was supplying hourly load data properly is to be in accordance with the open access transmission tariff. There's really no question.
That doesn't seem like a conflict then.
It
doesn't seem like that displaces any federal law. There's no conflict between the state and the federal there.
There is, because the only question is whether or not the federal tariff is whether Duke acted in accordance with the federal tariff. And the case law at the Supreme Court and at the Circuit Courts is the tariff is like a law. And so where the state court does not have jurisdiction to determine whether Duke acted in accordance with a federal tariff, FERC has that exclusive jurisdiction. And again, not just with respect to the supplying of the hourly load data, but the overall scheme that includes the remedy in the event there's an issue with how the data is provided. And those provisions of the PJM tariff are attached and referenced in Duke's supplement to its merit brief. I think it's worth pointing out too, because the commission has argued and Direct Energy has argued that the state commission has authority here because the state commission has authority over the tariffs that it approves. And we're not arguing that in general that's correct. Certainly the state does have authority over public utilities and also those provisions of the state tariff or of the service that are governed by the state tariff. But here, where the state tariff explicitly references the federal tariff, that issue then becomes one of federal jurisdiction and one of federal preemption. As a result, the issue here was not just that whether or not the Duke initially provided adequate or inadequate service. It is what is the remedy if there was something that was done that was not in accordance with the federal tariff. The several FERC cases that are cited in Duke's merit brief, including GDF Suez, the New York State Electric and Three Phases cases, all make it very clear that when there's an issue like the issue raised in this case, FERC has exclusive jurisdiction for the purpose of determining the remedy for establishing a final
Here did
process.
the resettlement process, is that something that was provided for in the OAT, or was that something that came from someplace else?
The resettlement processes A and B are part of the OAT. There's a resettlement process C that's a more voluntary process that Duke also pursued. And we know that the resettlement process worked in part because Duke was reimbursed for certain months. It was not totally reimbursed in part because the resettlement process has a very explicit intent of achieving finality. Sometimes that will be finality to the benefit of an entity like Direct Energy, and sometimes it won't be. But the FERC tariff and the OAT prizes finality and certainty of bills, and that is within FERC's jurisdiction to approve and to set those kinds of policies, even if the state ultimately disagrees and thinks there should be additional remedies. It's important to be clear here, though, too, that even if the PUCO had jurisdiction to interpret the federal tariff, which of course Duke argues it did not, PUCO made no such determinations in its order. We see nothing in the order that speaks to what is actually in the OAT, what provisions govern, what provisions were or were not complied with, what remedies might have been available under the OAT. And as a result, there's no fact or finding in the commission's determinations that would support its determination that Duke did not comply with the OAT, did not supply hourly load data in accordance with the OAT, and therefore provided inadequate service. Earlier, I touched on the issue, and I believe my time is up for until rebuttal.
Thank you.
Is that correct?
You're into your rebuttal time. You're correct.
Yes. All right. Thank you. I'd like to reserve my remaining 2 minutes.
All righty. First up, we have Ms. Blair.
Yes, thank you, Your Honor. May it please the court. I would like to reserve 3 minutes or the remainder of my time for intervening Appellee's counsel, Mark Witt, to argue. Duke dropped the ball in this case. Duke failed to perform a duty that it owed its customer, Direct Energy. Duke was obligated under Ohio Law 490522 to provide adequate metering services. It did not. Duke itself filed the tariff before the Ohio Public Utilities Commission. It asked for approval to provide meter data management services, the issue of this appeal. Duke, as a utility provider, is the only entity that can provide that service. Direct can go to no one else besides Duke. The facts clearly show that Duke made a mistake for 7 months in a row. SunCoke was a customer of Duke's. It produced and used electricity. When they took generation and distribution from Duke, the bills were manually calculated by Duke, and they were correct up until January of 2013.
Does federal law govern what happens if there's a mistake made in billing?
Well, that's what happened here. There are the two settlement processes. Settlement B can go back 60 days. And that's what happened here is they went back 60 days, but that did not take.
Why shouldn't we say, okay, the federal laws establish this procedure to resettle if there's a mistake? Federal law places an interest in finality. For PUCO to do something different would conflict with that process.
I don't think that there's a conflict because what was before the PUCO was the 490522 adequate services. This is a metering service. Duke owns the meters. Direct can go to no one else. Duke filed that tariff with the Ohio Commission. The Ohio Commission provided that. The Ohio Commission did not speak to the resettlement process whatsoever. The Ohio Commission did not interpret the oath.
But isn't this just a way around the resettlement process here?
I don't know what Direct will do with the opinion that is issued in this case, but the PUCO has a duty because it had the tariff filed before it by Duke, and it was asked with this under the complaint statute 490526, was this inadequate service according to 490522? And as you can see, according to the facts that the commission saw, Duke was able to provide accurate services. However, when Direct became the generation provider in January of 2000 bills, Suncoke's bills were inaccurate.
Is this a public utility service that Duke was providing here?
It is a public utility service. That's why Duke filed this.
How do we know that other than just that they filed the tariff?
It's metering. Metering is part of the distribution system. Also in this tariff, not the subject here, but further down, you will see that Duke has to own the meters, has to maintain the meters, has to make sure that the meters are
was
accurate.
Duke, I mean, the definition says supplying electricity for light, heat, or power purposes. Was it doing that when it provided the service?
It does facilitate the transmission service.
Well, that wasn't the question. What was Duke supplying here? Because that's the definition of electric light company.
Well, yes, and
public utility.
According to that definition, it was Duke's distribution facilities that allowed for delivery to this customer.
Well, was it engaged in the business of supplying electricity for light, heat, or power? It's not. I mean, lots of things allow things to happen, right?
Yes.
But was it engaged in the business of supplying electricity for light, heat, or power here?
Yes, metering is an integral part of supplying electricity. So it was by definition performing a Public Utilities Act. It was by definition a public utility. And again, back to the facts of the case, the commission focused on the facts that Duke was able to provide accurate metering data up until the point where generation was provided by Direct.
What kinds of things would you say would not be included in that definition of providing electricity? What isn't included? If you're saying this is included, they're providing this service that falls under the PUCO's jurisdiction. So what doesn't include? What isn't there? Clearing trees from lines, for example?
Well, no, that's a utility service because it's part of the distribution lines that has to do with delivering electricity to the end user. And metering is also a very important part of providing electricity to the end user. Off the top of my head, I'm sorry, Your Honor, I can't think of something that's not a regulated service. But then that's what we look at the commission is regulated services, of which metering falls in. And the tariff obligated Duke to provide accurate metering services to PJM, which they clearly did not.
Does it matter though that the complaint was brought by Direct and it wasn't providing electricity for Direct? I mean, there is this complicated relationship with PJM and with Direct Energy. Does it matter that it was Direct Energy that brought the complaint?
Well, Direct Energy was the proper party to bring this complaint because they're a transmission customer under the tariff of Duke's, according to Duke's supplier tariff filed at the commission. And Direct, in fact, notified Duke of this in February of 2013, the second month into the 7-month continued mistake. They were proper to bring this under 490526. This is the complaint statute regarding public utilities. And it is an avenue for a complaint for any rate, fare, or service provided by a public utility, which Duke is. Duke can't escape that for this metering services. And what that tariff provided was that Duke, acting as the designated meter data management for Direct, will supply hourly load data to PJM. Duke will provide this in accordance with OAT, the open access tariff filed at FERC. The tariff nowhere states that FERC has jurisdiction over this supplier tariff. And in fact, this Ohio tariff obligates Duke to provide accurate load data to PJM, the words of the tariff at the Ohio level.
Ms. Baer, does FERC have any jurisdiction here? Could Direct have filed a complaint with FERC instead?
Direct may file, that might be better directed to Mr. Whip, but if it had to do with the resettlement process and compensation, that may be. That was not jurisdictional to the PUCO in this case. Again, the PUCO did not look at the compensation or the market participant part of the OAT. It didn't in any way translate. It didn't look at that tariff nor seek to bring meaning to the OAT settlement process. It simply looked at the metering services according to the tariff and were they inadequate. And though Duke speaks to the OAT tariff, it's over 3,000 pages long, it doesn't pull anything about the metering information from that. And what the commission did is they saw Direct as a captive customer. Duke is providing a monopoly service here. The aggravating facts that the commission focused on were the metering services were correct before 2013, but after that, they were highly inaccurate. The meter service provided to state tariff was the sole issue that the commission looked at. It in no way interpreted a federal question and makes no claim that there was no claim that FERC, no claim by Duke, that FERC had a metering provision in the OAT tariff. The record contains sufficient evidence that the commission relied upon in making its finding that Duke provided inadequate metering services. The commission made no findings nor spoke to OAT that filed at the tariff. I'd like to speak briefly to the exculpatory language that is included in the metering tariff. The commission found that invalid because the Ohio Administrative Code does not allow exculpatory clauses. And when the commission adopted this rule, it was in fact codifying the commission's long-standing policy in the Ohio Supreme Court's case law that doesn't allow a body that provides a monopoly service to use that to use oppressive terms or things like that in their
Did the commission approve this tariff?
The commission did approve this tariff as a whole.
So why would they approve it with the exculpatory language then?
The commission didn't notice the exculpatory language when they
Didn't
approved
notice it?
It was approved, but they did when it was called upon to question it. In this case, the facts of it said the exculpatory clause cannot be because of the OAC. And I'd like to point out something else. In the tariff itself, this metering language is in section 14 along with the exculpatory language. However, if you go farther down in the supplier tariff in section 21.4, Duke itself puts language in there that says the supplier tariff and agreement are subject to present and future regulations or orders of any local, state, federal regulators having jurisdiction. So I will argue that in the tariff itself provided by Duke, it claims that will abide by the Ohio Administrative Code, which forbids exculpatory clauses. So I think on two fronts, the exculpatory clause should not be. The commission properly found that that clause was not valid. Our lights went out. And the claim that Duke also makes a claim that it was an inadvertent and isolated incident. This should be dismissed statutorily because that was not brought before the commission. That is in violation of 4903.10. It cannot stand before this court. It was also in violation of 4903.13. The inadvertent and isolated incident was not raised before the commission on rehearing, nor was it raised on the notice of appeal. Furthermore, if this court does choose to look at the facts, they made the isolated incident 7 months in a row, and it was brought to their attention by Direct in month 2. That is not isolated. The issue in this case is whether Duke's provision of metering service was inadequate. The commission looked at the facts and determined that the provision of service was inadequate. The decision was properly made, and this court should affirm the decision. Thank you.
Thank you. Mr. Witt? You'll have to unmute your microphone, Mr. Witt.
Chief Justice O'Connor, may it please the court. I'd like to start by addressing a question Justice DeWine had, and that was whether Duke was supplying electricity. The answer is that it was. It was supplying electricity to Suncoke. So this customer was a distribution customer of Duke and an energy supply customer of Direct. The complaint statute 490526 does not limit complaints to customers. The statute says that any person may file a complaint against a public utility. Persons as well as firm, corporation, etc. Direct is a corporation or firm that filed a complaint against Duke, which is a public utility by virtue of supplying electricity to customers. To answer Justice French's question, well, what wouldn't constitute public utility service? And among other examples that come to mind would be, for example, if one of Duke's bucket trucks rear-ended someone on the highway. Although Duke is a public utility, I'm not aware of any tariff provision that Duke has which addresses how it drives its bucket trucks. So that sort of claim would be subject to a court of general jurisdiction, even though Duke is engaged in the business of a public utility. In this case, we're dealing with a service that's expressly governed by Duke's tariff. And this is a tariff that Duke claims is enforceable by Duke, but not against Duke. And that simply doesn't make sense. There are dozens of suppliers in Duke's territory. And the reason this tariff exists is so that all suppliers are treated equally and fairly. And the obligation exists because Duke has a monopoly over its meters. It is the only person that can provide metering data to PJM. And when we look at the PJM tariff, if you look in Duke's supplement, pages 76 through 119, this is the tariff that they draw the court's attention to. That tariff says nothing about the allocation of responsibility or liability between a public utility and an energy supplier. All it provides for are procedures at PJM to reconcile these metering errors. And counsel has admitted that the order contains no findings about whether Duke complied with the federal tariff. The commission didn't have to go there because we weren't complaining about the time period that was subject to resettlement. Direct filed this complaint because of a time period outside of the PJM resettlement period. So the state jurisdiction here supplements FERC jurisdiction. It's not to the FERC.
Well, isn't that a conflict if federal law says, okay, you have to resettle something within this time period, and for the state to say, no, you don't have to follow those procedures, but you can resell it outside the time period?
Well, I would call attention to the Strategic versus Western Massachusetts Electric Company case. We cited that. I believe it was pages 9 and 10 of our brief. It goes through the preemption analysis, and it goes through and explains why there is no conflict between federal law and other contractual remedies that may exist between the utility and the supplier. Again, FERC's, and I think it's been agreed that the primary—
This isn't really a contractual remedy, is it? I mean, this is part of a state regulation.
Well, it is, although there is a contract between the parties that essentially says the parties agree to follow the PUCO tariff. So the tariff here has elements of both a contract and a statute. Regardless of which is the case, the tariff simply says that Duke will provide this information to PJM. And Duke admits that it didn't do so. What it provided, it may as well have provided nothing. And their claim is that they have no responsibility whatsoever for this obligation voluntarily undertaken, and that although they can require my client to pay various forms of supplier fees, that my client can be kicked out of the state by Duke if we don't comply with Duke's requirements, that Duke can do all of that, but we have zero recourse if Duke doesn't follow its obligations. And again, this is not an area covered by FERC. Justice DeWine, you asked the question, is there a statute that either expressly or by conflict preempts the state tariff? The answer is no. There's been no statute cited, and Duke just says over and over again, well, it's the OATT or the OAT preempts. Well, what language is preemptive? I haven't heard it. And the court ought to ask counsel, point out the specific language in the PJM tariff that preempts the PUCO, and they won't be able to find it. I see my time has expired. Thank you.
Thank you, Mr. Wett. Counsel, you've used about, or you have left about 2 minutes.
Thank you, Your Honors. I want to make very clear here that the only issue that is before the court with respect to the applicability of the supplier tariff is the issue of supplying hourly load data. And to counsel's last point, we would point directly to the PJM open access transmission tariff sections 3.6, sections 5.1. These are provisions that speak directly to how hourly load data is to be supplied to in accordance with the OAT. And because the state tariff in this one area with respect to supplying hourly load data explicitly relies on compliance with the OAT, that's where we are in the realm of the Federal Energy Regulatory Commission jurisdiction. And the provision of law that governs that is a supremacy clause of the United States Constitution, and a body of case law around it that makes very clear where FERC's jurisdiction is exclusive with respect to the tariffs that exist under the FERC jurisdiction. I also want to be clear here, there was some discussion about is Duke supplying electricity? Is Duke doing things under state law that make it a public utility? Counsel for the commission said, well, metering itself is a requirement, but so is setting rates. And the issue is not necessarily just whether or not there is an activity that exists that might fall under the question of the state law. There are multiple activities that an entity like Duke undertakes that could fall under state jurisdiction or could fall under federal jurisdiction, depending on the parties involved, the nature of the activity. And in this case, the case of supplying hourly load data, that is governed by the federal tariff. Just as if Duke was charging a wholesale client a rate, that is also a part of supplying electric service, but it is not a part of the commission's jurisdiction. Rather, the commission's jurisdiction is only over utilities that are actually supplying electricity, which Duke is not doing, to the entity in question. I also briefly on the exculpatory clause issue raised by counsel for the commission. The commission here and Direct Energy have extended the specific language of the Ohio Administrative Code that prohibits exculpatory clauses in the event of the negligence of the party, and to make it so like there can never be an exculpatory clause in a tariff. In this case, as commission counsel admits, that is in the tariff. The commission had the chance to review it, and there's been no finding of negligence here because that also is not within the jurisdiction of the commission. At the end of the day, however, the more important factor is that the only reason, even under just a plain reading of the administrative code, the only time there is no application of the exculpatory clause is when negligence exists, and that was not the case here. And I see my time has passed, so I thank you for your time today.
Thank you. Thank you, counsel. We'll take the matter under advisement and you'll be notified of our decision.